Hello, ladies and gentlemen. Thank you for standing by and taking the time to join us for today's webinar, Understanding the New Mortgage Servicing Rules. My name is Dan Voris, and I'm a Senior Marketing Associate with CliftonLarsonAllen. Before we get started, I'd like to cover a couple housekeeping items. If you experience technical difficulties, please dial 800-263-6317. If you have questions on today's content, we have planned for a question and answer session at the end of the presentation. Your questions can be submitted via the questions function. If you haven't already downloaded the presentation slides, another copy of the slides, as well as the webinar recording, will be emailed to you within the next 10 business days. And finally, we invite you to fill out the survey that will pop up as you leave the webinar. Your feedback helps us to build strong programs in the future. For those of you who may not be familiar with us, CliftonLarson is a professional services firm with 3 distinct business lines, including accounting and consulting, outsourcing, and wealth advisory. We have 3,600 staff members with offices across the country. Without further delay, I'd like to introduce today's presenter. Adam Bleck is the Senior Compliance Consultant in the Financial Institutions Group at CliftonLarsonAllen LLP, specializing in regulatory compliance consulting for financial institutions. Through reviews conducted both on-site and remotely, Adam builds relationships with our clients and assists them with the establishment and strengthening of existing compliance programs through targeted compliance audits, ongoing compliance consulting assistance, and staff compliance training. Before I turn it over to our presenter, I'd like to go over today's learning objectives. At the end of the webinar, you'll be able to understand the 9 new elements and policies and procedures required by them, recognize the exemptions that may apply to your financial institution, and be familiar with the small servicer mortgage rules. Let's move forward with the presentation. Adam, I'll pass the mic over to you to get us started.
Sounds good. Thanks, Dan. Good morning, everyone. Before we dig into the slides too far, I would like to tell you that I'm really excited to be able to speak to you about the upcoming mortgage servicing rule requirements. And as we speak, there are apparently some rumbling in the Senate that they would like to push back the implementation dates of all the mortgage industry changes. Perhaps we'll get an early Christmas present this year, but we'll have to see. As of now, the topics we'll be reviewing are still under the deadline of January 10th, 2014. In planning this webinar, I was worried that December being a webinar date to discuss these topics might be a little too late. But at last count, we had over 300 different financial entities signed up to listen to today's topic. Some of the commentary that I'll speak about today is based on the questions that my compliance team and I have been receiving. And based on the volume of questions that we're getting, it's obvious that the servicing rules are definitely front and center on a lot of minds in the banking and credit union circles. The plan for today is basically to walk through the servicing rules and hopefully shed a little light on some of the areas that you might not know a whole lot about. I only have an hour to discuss these rules with you, but there are several hours worth of material to talk through if we broke out each individual topic. With the upwards of 900 people on the call, I will most likely not be able to field all of your questions, but I would like to do my best to help answer your questions, so even if it is after today's call. I believe that the phone lines are all muted, so let's feel free to kick back, grab some popcorn maybe, attach an IV drip of coffee or an energy drink of your choice, and let's dig into some of the biggest changes in our industry in recent history. When it comes to the new mortgage servicing rules, we're basically looking at 2 big rule changes, both to Regulation X and Regulation Z. Between the 2 rules, we're talking about 9 significant topics. 6 of them fall under the RESPA requirements, and 3 roll up under the Truth in Lending Act. We also need to look into what types of exemptions there are, including the definition of a small servicer, and this not-so-little caveat is going to have some big implications to the majority of credit unions and community banks. Under the RESPA servicing rules, we have the following topics to review today. Error resolution and information requests, force-placed insurance, general servicing guidelines, early intervention with delinquent borrowers, continuity of contact with delinquent borrowers, and loss mitigation procedures. Under the Truth in Lending Act servicing rules, we have periodic statement requirements, interest rate adjustment notices for adjustable rate mortgages, and the prompt crediting of payments and payoff statements. On January 17th, the Consumer Financial Protection Bureau, basically the CFPB, as I'll be talking about them as we go, issued over 700 pages of final rules pertaining specifically to the mortgage servicing practices. The rules, amending, like I said, both Reg X and Reg Z, require compliance by the January 10th, 2014 date. The rules implement provisions contained in the Dodd-Frank Act, which were designed to improve the information consumers receive from mortgage servicers and protect consumers and customers from mortgage servicing errors. The rules include a very important exemption for small servicers, mortgage servicers, that service 5,000 or fewer mortgage loans and service only mortgage loans that they originate or own. The original proposed rule had set that exemption at a low 1,000 loan level. This exemption level was then raised from 1,000 to 5,000, which is very good news for both banks and credit unions. Open lines of credit, home equity plans, are generally exempt from the requirements in the 2013 RESPA servicing final rules. In addition, the general servicing policies, procedures, early intervention requirements, continuity of contact, and loss mitigation procedure provisions are generally inapplicable to servicers of reverse mortgage transactions or to servicers of mortgage loans for which the servicers are also qualified lenders under the Farm Credit Act of 1971. A client of mine recently asked, would we meet the small servicer exemption if we currently own, originate loans, and sell these to Freddie Mac and or Freddie Mae, but retain the servicing rights and have less than 5,000 loans? The answer would basically be yes. You would meet the exemption criteria based on the number of loans specifically being less than that 5,000 loan mark. When it comes to the servicing rules, it's important to understand the full scope of the rules. The new rules apply only to servicers. And with the new rules, the definition of servicer technically remains unchanged. But the rule does cover what are now defined in the rule as mortgage loans. A mortgage loan is basically something that includes subordinate lien loans, but it does not include, like I said before, home equity lines of credit. The use of the term mortgage loan has been updated to be defined as a federally related mortgage loan, which in turn is subject to RESPA standard exemptions, such as being a business purpose loan or a loan for vacant land. As with any rule, it's the exemptions that exist to throw a wrench into everyone's processes and to totally confuse us all. Some exemptions of the 2013 RESPA servicing rule include servicers being qualified, like I said, under the Farm Credit Administration Act, servicers of those reverse mortgages, and those considered to be small servicers. Now, it's important to fully understand the small servicer exemption, and it should be noted that even if you're considered to be a small servicer and fall under the exemptions, that you should be aware of the existing rules and the requirements, basically in case there are any future mergers or acquisitions, or if your institution is skirting that 5,000 loan threshold. Just to clarify, in order for any loan to be counted towards that 5,000 loan total, the financial institution or its affiliate must retain those servicing rights, even if that means they use a subservicer to actually do the servicing. Also important to note is the definition of mortgage loan for determining the number of loans serviced. Under Reg Z, in Section 1026.41, basically which governs all the small servicer exemptions, a mortgage loan is a closed-end consumer credit transaction secured by a primary dwelling. Again, as I noted before, HELOCs don't count towards that 5,000 total, and neither do loans with the primary purpose other than being personal, family, or for household purposes. Basically, an organization is exempt if the servicer that services less than or equal to 5,000 mortgage loans, for all of which the servicer or their affiliate is the creditor or the assignee, or if the servicer is a housing finance agency as defined by the HUD regulations. So, how do you know if you qualify as a small servicer, you ask? Well, Let me tell you. There is a small servicer determination that must be made as of the 1st of January of each year. If the servicer that crosses the less than or equal to 5,000 loan threshold, they have 6 months or until the next January 1st, whichever is later, to comply with the requirements for which the servicer is no longer exempt as a small servicer. Remember that the 5,000 loan transaction exemption does not cover all of the requirements. For example, the requirements for error resolution and information requests procedures will apply to all banks and credit unions performing mortgage servicing. Also, interest rate adjustment notices for adjustable rate mortgages and the prompt crediting of payments and payoff statements will still apply. Additionally, keep in mind that the small servicer exemption only applies to the CFPB's mortgage servicing regulations. I have an example of a question that I actually received yesterday. We currently service less than 5,000 mortgage loans. However, our loans are serviced by an outside loan servicer and under the mortgage statement requirement due to the volume of that servicer. We hold less than 500 mortgage loans for agricultural and commercial real estate, along with second lien real estate that are not part of the loans that we have serviced by that outside servicer. Our credit union league is stating that we do not have to follow the mortgage statement rules on our in-house portfolio, which they consider to be separate from the servicer loans. Is this correct? Technically, yes, the league is actually correct. Number one, because you're servicing less than 5,000 loans, and in order for the loans to be counted towards that 5,000 loan total, a financial institution must retain the servicing rights, even if that means they use a sub-servicer to do the actual servicing. Let's dig into some of the RESPA servicing rules here. The first of which is the error resolution and information request processes. Now, for any written notice, and the important piece here is written, for any written notice from the borrower that asserts an error, some examples might include failure to accept or apply a payment timely, or failure to pay escrowed expenses, or maybe a failure to provide payoff details timely. That all includes basically the name of the borrower, the information that enables you to identify the borrower's mortgage loan, and the error the borrower believes has occurred. You have to provide the borrower with a written response acknowledging the receipt of that notice of error within 5 business days. That's very important. Also, you must correct the error or errors identified by the borrower and provide the borrower with a written notification of the correction, the effective date of that correction, and contact information, including a phone number for further assistance, or conduct a reasonable investigation and provide the borrower with one of the following. You either have to provide them with a written notification that includes a statement that you have determined that no error actually occurred, a statement of reason or reasons for that determination, or a statement of the borrower's right to request documents that you relied upon in reaching your determination. In addition, information regarding how the borrower can request those documents, the contact information, like I said, including a telephone number for further assistance, must all be provided. Time limits are especially important here, too. Basically, the time limits for you to investigate the error and to provide notification vary depending upon the type of error being reviewed. But it is generally 30 business days after receiving the notice of error. The time period is just 7 business days for failure to provide an accurate payoff balance, and is the earlier of 30 business days or the date of foreclosure sale for pursuing foreclosure too quickly or failing to follow the loss mitigation provisions. In such cases, you only get a 15-day extension, and that's one of the conditions that technically, if we wanted to dig into more detail, we definitely could. But you are not required to comply with all the other statements or notifications if you correct that error and notify the borrower of that correction within 5 business days of receiving that notice of error. You are also not required to comply with the previously noted statement or notifications if you receive notice of a foreclosure procedure 7 or fewer days before actual foreclosure sale. However, you must make a good faith attempt to respond to the borrower, either orally or in writing, and either correct the error or state the reason you determine that no error has occurred. You may request additional information from that borrower as well, but you may not require the borrower to provide the information as a condition of actually investigating that error. And you may not determine that no error occurred because the borrower failed to provide that requested information to you. Servicers also have the ability to use a specific address for error and information requests. However, the financial institution doesn't need to designate a specific address that a borrower must use to report an error. With that being said, if a financial institution does not designate a specific address that a borrower has to use to report those errors, a servicer must respond to a notice received by any office or location. So, the fewer number of offices, the less likely the reason to designate a specific address would be. Another piece, too, the fewer the number of locations you have, the less likely there is a chance for any of those errors or questions to fall through the cracks. If you do establish an address that a borrower must use to submit a notice of error, you must provide a written notice to the borrower indicating the address, and you also must post that address on your website. I would also reiterate the point that the resolution requirements in the new rule are not required unless you receive a notice of error or information request in writing. If you are able to assist the borrower with their issue over the phone or in person, these requirements do not apply. There are also several pieces to note with error resolution and information requests. You are not required to follow these error resolution rules if there is a duplicative notice of error, an overbroad notice of error, or an error received more than 1 year after you transfer any servicing rights or 1 year after the loan is discharged. You must, however, notify the borrower if you are not following the error resolution rules due to one of those reasons within 5 business days after making that determination. The notice to the borrower shall set forth the basis upon which you are not investigating that error. In addition, you cannot charge for investigating an error and cannot report adverse action information to a credit reporting agency for 60 days when the payment amount is the subject of that notice of error. However, you may still pursue any remedy that you have under applicable law, including initiating foreclosure or proceeding with any type of a foreclosure sale. There's going to be a need to monitor response times for the specific error types and for information requests. So for each financial institution, it's going to be really important to determine if there's any way to track those open requests and complaints and basically make sure that the time frames for those are being met. For information requests, the servicer requirements under the rules are basically consistent with those that apply for the notice of errors. Servicers have to acknowledge the requests within 5 business days and have to resolve them within 30 business days. The only exception is here it basically involves requests that ask for the identity of an address or other relevant contact information for the owner or assignee of a mortgage loan, which requires a response within 10 business days. Requests for payoff statements are not treated as requests for information under that rule. So that's another interesting little caveat to the rule. These rules are going to continue to morph and change as the CFPB sees fit. In October, the CFPB made some clarifications relating to error resolution and information requests. The servicing rule provisions basically require servicers to, number 1, investigate and resolve certain borrower-reported errors relating to the servicing of that borrower's mortgage loan. Number 2, respond appropriately, and I take that to read timely, to any borrower requests for information with respect to that loan. And number 3, consider appropriately or timely a borrower's loss mitigation application. The CFPB basically looks at a borrower's cease communication request, which basically is allowed under the Fair Debt Collection Practices Act, the FDCPA, basically should ordinarily be understood to exclude these different categories of communication, basically because the borrower has specifically requested the information possibly at issue. So even if the borrower sends a cease communications request, while a specific action the borrower requested of the servicer is in process, the borrower is still considered to have been excluded from having to worry about that general request for a cease communication. So really, even if they've requested that you stop sending them information, you still have the right under these rules to go around the Fair Debt Collection Practices Act. The second RESPA-related servicing requirement has to do with the managing the processes for force-placed hazard insurance. That's very important there. Hazard insurance, remember that. At least 45 calendar days prior to assessing a charge for force-placed hazard insurance on a borrower, you must deliver the borrower a written notice that contains specific information. And rather than detail out the specifics of the notices, I've included a link here on the slide, basically from Regulation X. And it's got the model form, which is MS-3A. That's the one that you'd want to use for that specifically. You must also provide a reminder notice at least 30 days after the initial notice and 15 days prior to assessing a charge for the force-placed insurance. If you haven't yet received any hazard insurance information from the borrower, there's a specific notice that has to contain specific information, and that would be one of the other model forms under MS-3B. Another caveat, if you have received information from the borrower, but they have not yet provided evidence of paying current that hazard insurance, the notice must be sent out with a different model form, MS-3C. Finally, if force-placed insurance is in place and the policy is renewing, you must provide a notice at least 45 days before charging the fee or charging the borrower. And then, again, there's a model form for that, which are all posted up at that link. If the borrower provides you with evidence demonstrating that hazard insurance coverage was in place, that basically complies with the loan contract's requirements in order to maintain that hazard insurance, you must, as the financial institution, within 15 days, cancel the force-placed insurance and refund to the borrower all the force-placed insurance premium charges and related fees paid by the borrower for any period of overlapping insurance coverage. And in addition, remove from the borrower's account all force-placed charges, basically that you assessed to that borrower. Also, all charges relating to the force-placed insurance assessed to the borrower must be bona fide and reasonable. So as a word of caution, I would make sure that all the charges have backup documentation available for review. Here are two questions that I received from a client, or actually my team received from a client this week. For force-placed insurance, I understand if a member has an escrow account but doesn't have the funds to cover their homeowner's insurance, do we still have to pay it? And if the borrower, here's the answer, if the borrower has an escrow account for the payment of insurance premiums, the servicer has to continue to pay the borrower's insurance, even if the servicer needs to advance funds to the borrower's account to do so. So all of this assuming that there hasn't been any cancellation or non-renewal notices received in that process. The next question, what if there is no escrow account? Do we still have to pay for the member's homeowner's insurance, or can we use force-placed insurance? If there's reason to believe that a borrower has not paid their insurance premiums, then they can force-place insurance. However, they must make sure they are sending out the proper notices at least 45 days before the service charges go to the borrower. And again, you have to send at least 15 calendar days before those charges hit the borrower's account as well. The third guideline has to do with the general servicing policies and procedures and quote-unquote other requirements. Servicers that qualify under the small servicer exemption are technically exempt from this requirement. Servicers are required to establish reasonable policies and procedures for maintaining and managing information and documents that are related to borrower communication, error resolution, information requests, loss mitigation, foreclosure, and other servicer operations. So servicers can determine the specific methods by which they want to provide that reasonable information and management policies and procedures. However, the servicers do need to maintain policies and procedures that are appropriate for the servicing businesses in light of the size, the nature, and the scope of that servicer's operations. So my recommendation here is that with any policy or procedure, I would recommend making sure that they are board approved, similar to what you might have your board review, your BSA policy manual or procedures with. So Again, this one's going to come down to a lot of paperwork, but really writing down your processes and procedures and making sure that they're really relevant to your business. Another important piece of the general policies and guidelines includes proper record retention and the ability to assemble a servicing file when requested. So record retention requirements note that a servicer must retain records for each mortgage loan until 1 year after the loan has been discharged or transferred. The second piece is the servicing file. The file must be maintained in a manner where the servicer can compile information into a servicing file within 5 days. You can assume that these aren't going to be just one file or two files when the examinations come through. They're probably going to be asking for a pretty good chunk. So it also has to do with you need to be able to include an account history of all the transactions credited and debited, including any escrow and suspense account activity, a copy of the security agreement. The file also needs to include any communication notes about the mortgage account created by the servicer personnel. Be careful here because any underwriting or sticky notes possibly left in those loan files can also be assembled when these servicing files are put together. You also need to be able to report data fields by name and then also include any copies of information or documentation provided by the borrower. And really, a borrower can request a servicing file, which is then subject to basically the information request provisions that we already talked about. So from what I've seen in most institutions that have all these types of data, when it's going to have to be pulled, you're going to be looking at different areas of the organization getting involved, crossing different operating platforms in some cases. So it is really important to make sure that there's procedures in place for when the time comes, this requested information can be assembled efficiently and repeated. The fourth topic under the RESPA guidelines has to do with the early intervention of contact with delinquent borrowers. A good quote I read is that the CFPB requirements put these rules in place to, quote-unquote, spur engagement between servicers and borrowers in an attempt to increase the borrower's ability to avoid foreclosure. They also noted that early intervention may benefit the borrowers by reducing avoidable interest costs and by limiting the impact on the borrower's credit reports. So it sounds good in theory. The other notable parts of this rule include that they have to be compliant with the early intervention rules. So basically, you have to make live contact. A servicer has to establish or make good faith efforts to establish live contact with a delinquent borrower not later than the 36th day of the borrower's delinquency. And prompting after establishing that live contact, inform the borrower about the availability of different loss mitigation options if it's appropriate. All of this must be done as a good faith effort, meaning that the financial institution has to make reasonable steps to reach out to the borrower by telephone more than once or by sending written or electronic communications to establish that live contact. There's also a written notice requirement. A servicer has to provide a delinquent borrower a written notice with the required information not later than the 45th day of the borrower's delinquency. A servicer is not required to provide that written notice more than once during any 180-day period of time. So the written notices, just to run through real quick, they have to have a statement encouraging the borrower to contact the servicer. They also have to include a telephone number in order to get a hold of that servicer personnel. If it's applicable, there also has to be a statement including a brief description of examples of loss mitigation options that could be available depending upon the situation, and either application instructions or a statement informing that borrower of how to obtain more information about those loss options that they would have. The website, basically to either access the CFPB or the HUD list of home ownership counselors or counseling organizations, and the HUD toll-free phone number is also a requirement for those written notices. One question you might have, too, is what about unresponsive borrowers? The biggest thing here is that the CFPB believes that a borrower's failure to respond to a servicer's repeated attempts at communication, in accordance with all these early intervention rules, is it's relevant. It's a good concern. Really, for example, if the good faith efforts to establish that live contact basically has occurred after 6 or more consecutive delinquencies, it might require that you really don't have to make more than a single phone call or even a single sentence requesting the borrower to contact that servicer on some type of a periodic statement or electronic communication. Really, such efforts might be appropriate where there is little or very no hope of home retention, such as when all the applicable loss mitigation options have been exhausted. So maybe like a short sale or a deed in lieu of foreclosure. These types of things might happen later in the stages of foreclosure, but they definitely have some more timing requirements as far as those notices are concerned. This is an interesting topic. Based on some of the information that was updated by the CFPB as part of their October 15th update, they noted that starting on January 10th, 2014, a servicer must have policies and procedures reasonably designed that, based on notification of the death, the death of a borrower, that the servicer promptly can identify and facilitate communication with the successor, basically of that deceased borrower, in respect to the property that secures that deceased borrower's mortgage loan. In issuing the guidance, really what the CFPB is hoping to do is they want to assist servicers in implementing policies and procedures to promote home retention whenever possible for the successors that are basically faced with the loss of their home due to the death of that borrower. The CFPB also adopted some provisions that the financial institution has to be able to fulfill once they find out about that loss. So some examples of practices that the CFPB is actually recommending. Number one, promptly providing to any party claiming to be the successor of an interest, a list of all the documents that they would need in order to basically be able to establish the death of that borrower, and also be able to establish the legal interest of that successor in that property. They also need to identify and evaluate any issues that the issuer could consider in reviewing the rights and obligations of those successors with respect to the property of that mortgage loan. So receipt of acceptable proof of the successor's identity and making note, if it is a family member or if there's something listed in a will, possibly. Other prerequisites might include whether they have an option to continue the payment on that mortgage loan, assume the mortgage loan, or possibly qualify for any loss mitigation options as well. So these are all policies and procedures that the CFPB is recommending are implemented and ready to go as of January 10th. Promptly providing successors an interest, any documents or forms or other materials where they can continue to making payments for that loan, and basically any required documents or forms or materials, promptly evaluating that successor for possibly turning that loan over to them if they qualify. So in addition to the things I talked about, it's really important to make sure that upon notification of the death of the borrower, that a servicer is able to postpone or withdraw any pending or planned foreclosure proceedings and basically begin any of those loss mitigation options. So it's pretty interesting that you can definitely tell the CFPB is a consumer-driven agency when they're enacting rules specific to deceased borrowers. As I mentioned a couple of slides ago, the CFPB issued guidance regarding the interplay between the RESPA and Truth in Lending final rules and the Fair Debt Collection Practices Act, which is that FDCPA. The CFPB gave an opinion, like I said, that the cease communication requirement and how it relates to the mortgage servicing final rules. And, just to summarize, the CFPB concluded that cease communication option does not generally make servicers who are debt collectors liable under the FDCPA if they comply with certain provisions of Reg X and Reg Z. And really, they're considered to be a collector under that provision of the FDCPA if they are providing disclosures and communicating with the borrower in relation to these rules. So basically, if you're following the rules in regards to early intervention and collection, the biggest thing is that even if that member or consumer or customer basically wants to cease communication with you, you still have to go through the processes in order to send out communication, such as the early intervention rules, like I noticed, or the adjustable rate mortgage interest rate adjustments, along with that corresponding payment change. So if that information is going to be applicable, you need to make sure you're sending that out. The fifth rule basically specifically notes the continuity of contact with delinquent borrowers and the servicers and what they're required to do when it remains in maintaining policies and procedures that are reasonably designed to achieve the assignment of personnel to delinquent borrowers by the time a servicer provides that borrower with the written notice. So basically, regardless, and not later than the 45th day of that delinquency. You also have to make the borrower via telephone available or have them assigned with personnel who can respond to the borrower's inquiries. They have to be able to assist the borrower with available loss mitigation options until that borrower has made 2 consecutive mortgage payments in accordance with the terms of any permanent loss mitigation agreement without incurring a late charge. You also have to ensure that the servicer can provide a live response to a delinquent borrower who has contacted the personnel but may not receive a live response right away. So there's a significant amount of responsibility placed on the functions of servicer personnel. A servicer should maintain policies and procedures that are designed to ensure the servicer personnel assigned to a delinquent borrower can basically do the following functions. They need to be able to provide that borrower an accurate information about the loss mitigation options, like I already noted. They also need to be able to provide the actions that the borrower must take in order to be evaluated for those loss mitigation options, including what the borrower has to be able to do to submit an application for those options. They have to be able to take the appeal through the servicer's determination in order to deny a loss mitigation application. The personnel also have to be able to discuss the status of any loss mitigation application that the borrower had previously submitted to the servicer. The circumstances under which the servicer may make a referral to foreclosure, anything like that, they have to be able to speak to the borrower about that process. In addition, they also have to be able to retrieve, in a timely manner, a complete record of the borrower's payment history and all written information that the borrower has provided to the servicer. So finally, the servicer personnel has to provide a delinquent borrower with information about the procedures for submitting a notice of error or that information request that we already talked about. So there's definitely going to be more of a focus on the staff and what that personnel are able to do. The sixth rule basically looks into loss mitigation processing. And loss mitigation is basically any alternative to foreclosure that's offered by the owner or assignee of a mortgage loan that is made available through the servicer to the borrower. And basically, we could spend an hour specifically on this topic alone because the requirements for loss mitigation can include forbearance or loan modification options or non-home retention options. The final rule makes no formal requirement that a servicer has to offer loss mitigation options. However, documented procedural steps are required prior to the initiation of foreclosure or proceeding to a foreclosure sale. So note that servicers that qualify under the small servicer exemption are exempt from this requirement, except that the small servicer must still comply with the dual tracking limitations of the loss mitigation procedures. From a timing standpoint, if an application is received 45 days or more before a foreclosure sale, the servicer must promptly review the application to determine if the application is complete and acknowledge receipt of that application within 5 days. Anybody see a trend with this 5-day notice? If a complete application is received more than 37 days before the foreclosure sale, the servicer has to evaluate that borrower for all loss mitigation options available to that borrower within 30 days and provide that written notice of determination. Finally, if a complete application is received 90 days or more before that foreclosure sale, the servicer has to allow the borrower 14 days to accept or reject any loss mitigation offer. So there's a lot of different details in here, but the timing of this is very important. If a receiver a servicer receives a complete application less than 90 days but more than 37 days before that foreclosure sale, they have to allow the borrower 7 days to accept or reject that loss mitigation offer. So a borrower may appeal a servicer denial, basically of any permanent loan modification that's available if the application is received 90 days or more before that foreclosure sale. Under the rules, the borrower also has 14 days to appeal after the servicer provides that notice of the offer. So again, timing is a big piece of these loss mitigation procedures. Also note that no further appeals are available after determination has been made. So another important timing piece is the fact that the servicer must wait until a loan is more than 120 days delinquent before making this what's called the first notice or filing that's required for disclosure. So we've gotten a lot of questions about what this notice of first notice or filing is, so I'll spend a little bit of time talking about that on the next slide. Servicers are restricted if the borrower has already submitted a complete loan application by the applicable deadlines and is pending review. So basically, you can't start any other foreclosure proceedings if somebody has started this process for loss mitigation options. And as I mentioned, there are two small servicer dual tracking limitations. The first is that a servicer may not make the first notice or filing required for disclosure unless that borrower is more than 120 days delinquent, so that's an important one. And second, a servicer may not proceed to foreclosure judgment or order a sale or conduct a foreclosure sale if that borrower is performing under the loss mitigation agreement that they had approved. Whether a document is considered that first notice or filing is determined really on the basis of foreclosure procedures under the applicable state law. So where foreclosure procedures require a court action or proceeding, a document is considered the first notice or filing if it is the earliest document required to be filed with a court or judicial order in order to follow that or commence the action or proceeding. Where a foreclosure procedure does not require an action or a court proceeding, under an example would be a power of sale, a document is considered to be the first notice or filing if it is the earliest document required to be recorded or published to initiate that foreclosure process. So, in addition, where a foreclosure procedure does not require any court filing or proceeding and does not require any document to be recorded or published, a document is considered to be the first notice or filing if it is the earliest document that establishes, sets, or schedules a date for the foreclosure sale. So a document that's provided to the borrower but not initially required to be filed, recorded, or published is not considered to be that first notice or filing on the sole basis that the document must later be included as an attachment accompanying another document that's required to be filed. So I'm up here in the land of 10,000 very frozen lakes, and I believe here in the state, the first notice, in the state of Minnesota anyway, is the public notice that is put in the newspaper. So your state may be a little bit different, but that's definitely going to be something you need to look into when it comes to any foreclosure processing. Switching gears a little bit, the first notable rule change under the Truth in Lending Act declares that a servicer of a mortgage loan must provide the consumer for each billing cycle a periodic statement. The rule is specifically related to closed-end residential mortgage loans, and really you have to provide a periodic statement to the borrower for each billing cycle, with the exception of fixed-rate loans where a coupon book is provided. Periodic statements must be sent no later than 4 days after the end of the billing cycle. There are 4 specific exemptions for this, and they have to do with reverse mortgages, timeshare plans, and like I said, fixed-rate loans if the servicer provides a coupon book with the required information in it, or if you are a small servicer. So this does qualify under the small servicer exemption. The rule also has specific details for the form and the content of the statements and the notes that have to be shown on those statements. They have to reflect the current payment that's due with a breakdown of the monthly payment into principal, interest, escrow, and any fees charged. The statements also must reflect the application of past due payments, any delinquency information, those due dates, and contact information for servicers and those counselors. If a borrower is at least 45 days delinquent, the rules require that an additional information noting the date of that delinquency, any loss mitigation options, any foreclosure activities, and the servicer's contact information be on or sent with each periodic statement. Statements can be sent to the borrower either in writing or electronically if the borrower has given their proper consent, and that's basically a dovetail right into e-sign. The coupon book exemption is allowed for borrowers with fixed-rate loans who are given basically the same information available on a regular statement, but in the form of a coupon book. However, the CFPB requires certain pieces of information be listed on the coupons themselves, including a monthly statement amount or monthly payment amount, a breakdown of principal, interest, and escrow, and total fees imposed since the previous payment cycle are just a few. This could prove to be very difficult to fit, number one, just onto a coupon based on size. Delinquent borrowers with coupon books still need to be sent delinquency information, but it's just done in a separate letter. So also the rules do note that if a borrower requests this information, then it all has to be made available to them as well. So there's going to be, number one, you've got timing, but now you've also got some formatting things when it comes to these statements. The second Truth in Lending Act rule pertains to the notice requirements for adjustable rate mortgages. Essentially, it revises the existing requirements for interest rate adjustment disclosures for ARMs with or without a corresponding change in payment, and it adds in initial interest rate disclosures for those adjustable rate mortgages. As far as the scope for these notices, it's going to be required for closed-end consumer credit transactions secured by the consumer's dwelling in which the annual percentage rate may increase after consummation. So any creditor, assignee, or servicer of any ARM is going to have to comply with this rule. As always, there's a couple of exemptions. Mortgage loans with a term of 1 year or less are exempt entirely from these notice requirements, and loan modifications made for loan mitigation purposes don't require these notices if there is no change in payment or if the disclosure does not need to be provided in that case. Notice requirements basically note that disclosures must be sent in a separate document, and if they're mailed with other documents, they must be sent as a separate attachment. And again, rather than sending or going into the detail of what's required, I'm going to basically recommend that you take a look at the link that I put on your slide. There are a couple of examples of H4D4 and H4D3. Timing is really the most critical piece when it comes to this part of the rule. The notice must be provided 210 days, but no more than 240 days before the first payment at the adjusted level is due. If the first payment at the adjusted rate is due within the first 210 days after loan consummation, it must be provided at consummation. The other piece here too, due to the disclosure timing issues and the effective date of the rule, this initial disclosure is only required on ARMs where the new payment due date at the adjusted level is on or after August 8th of 2014, which is basically 210 days after the effective rule date of January 10th, 2014. The technology and the support that are going to be needed to make sure of that timing, the timing of these notices is accurate, is going to be very, very important going forward. One other piece, too, when it comes to more truth in lending servicing rules, this specifically talks about the revising of the existing requirements for an initial rate adjustment disclosure for an ARM with or without a corresponding change in payment in two key respects. Number one, it eliminates the annual notice requirement when an interest rate adjusts during the course of the year without a corresponding change in payment. And secondly, it revises the current disclosure when an interest rate adjustment results as a corresponding change in payment. This change in payment notice is required in addition to the notice explained on the other slide, which a teammate of mine dubbed as the initial or early notice. when the information on the early notice is an estimate, which will usually be the case. However, if the information on the early notice is not an estimate, this second disclosure is actually not required. So, again, if there's no change in payment, this disclosure does not need to be provided. This rule specifically concerns, again, closed-end consumer credit transactions secured by the consumer's principal dwelling, in which the annual percentage rate may increase after consummation. So, again, any creditor, assignee, or servicer of any adjustable rate mortgage, this includes financial institutions and non-financial institutions, this disclosure is required for any change in payment resulting from an ARM conversion to a fixed rate type of transaction. So, similar to the last adjustable rate mortgage slide, there are a couple of exemptions. Those ARMs with a 1-year term or less. The first interest rate adjustment to that adjustable rate mortgage, if the first payment is adjusted to a level 210 days after consummation. And when it comes down to the content and timing and format requirements, it's very similar in regards to the other form that I mentioned, but as far as timing, this notice must be provided at least 60 days, but no more than 120 days before the first payment at that adjusted level is due. So exemptions to the standard timing requirements, loans that originated before January 10th of 2014 with look-back periods of less than 45 days are exempt, and ARMs with a uniformly scheduled interest rate adjustment that occurs every 60 days or more often. Due to the timing issues here with this effective rule date of the 10th, this initial disclosure is only required on ARMs where the new payment due date at the adjusted level is on or after March 11th, 2014, which is 60 days after the effective rule date of January 10th, 2014. So, again, for these transactions, the disclosure must be provided to the consumer at least 25 days, but no more than 120 days before that first payment at the adjusted level is due. So I would recommend making sure that from a formatting perspective, you've got everything out. And like I'll note, actually, in a couple slides, there's definitely some reference material that the CFPB has put out to make sure that you got the right models that you're using for that. Looking at time, I'm going to continue on real quick. We're in the home stretch. So the final rule change to the truth in lending requirements requires servicers to process those periodic payments for both open and closed-end mortgages, meaning periodic being defined as they receive enough funds to cover the amounts due for the principal interest and escrow credited at the date of receipt, except when a delay in crediting does not result in a charge to the consumer or in the reporting of negative information to a consumer reporting agency. A periodic payment qualifies even if it does not cover late fees or the fees that have been assessed. Also, to note under the final rules is that servicers do not have to process a borrower's partial payment. This allows servicers the flexibility of either rejecting the payment, crediting it immediately, or holding it in a suspense account. If the partial payment is accrued in a suspense account or unapplied funds account, the funds must be treated as a periodic payment that's been received, and once there are sufficient funds available to cover that periodic payment, they can make that. If a servicer holds that partial payment, they must disclose the amount of the funds being held on a periodic statement. The final rules also do detail the treatment of non-conforming payments, which are those payments that are not received through servicer's specific requirements. For a check that's maybe mailed to the wrong address that is eventually sent to the correct location. Since those types of payments don't go through the authorized payment channel, they may result in delays crediting or identifying those payments. So servicers are actually not required to credit those payments at the date of receipt, but are allowed to credit those payments up to 5 days after the receipt. So that's an important little caveat to this rule. In the event that a borrower requests a payoff amount, meaning that the total outstanding balance required to pay the debt obligation in full, the rule requires that servicers provide payoff statements within a reasonable time, but in no case more than 7 business days after receiving a written notice from that consumer or someone representing that consumer. The 7-day timeline does not begin until the request is received from that borrower. So rather than sitting on a payoff request or trying to save it like back in the good old days, you're actually going to have to get all that foot dragging done within 7 business days. The new rules make no substantial changes to the existing prohibition on pyramiding of late fees, but does note that a servicer, in connection with a consumer credit transaction secured by that principal dwelling, may not impose a late fee or delinquency charge if, 1, the fee or the charge is solely attributable to a non-payment of a late fee or delinquency charge on an earlier payment, or 2, the payment is otherwise a periodic statement or a periodic payment received on the due date or within the applicable courtesy period. I'm sure that one of the questions on your mind might be, how will this impact home equity lines of credit that we already have on the books? And I can tell you that CFPB decided to almost exempt home equity lines of credit from the rules entirely. However, there are 3 quick facts to note. Home equity lines of credit are subject to the prompt payoff statement rule. The rule is simply that if you receive that written request from that consumer or any person acting on behalf of the consumer, you must provide an accurate payoff statement of the total outstanding balance that would be required to pay the obligation in full as of a specified date. So, again, that must be sent within 7 business days after receiving the request. And I noted that HELOCs are almost exempt from the servicing rules. They are still bound to the periodic statement requirements and the error resolution and information request requirements as well. While researching some of the background information for this webinar, I did come across a couple of interesting notes here as well. And really, to paraphrase a CFPB staffer, they noted that there are going to be 300 CFPB field examiners, and don't forget, those guys are looking at the big boys. These rules are definitely going to trickle down to the other examiner levels. She offered her assurance that the Bureau staff is going to be cooperative with servicers in helping navigate the rules via transparency and discretion about their findings, overall with the goal of minimizing risks to the consumer. So based on the information I found, it's very evident that servicers are going to have to show the CFPB that they have reliable systems to provide the Bureau and examiners the data that they are looking for in a timely manner, basically with ease of access and with a high level of data integrity. So lastly, I'd also like to make mention that the CFPB has all their contact information available, including a phone number for guidance inquiries. I called it personally, and I noted that they will offer you a verbal response only to your question. However, they also noted that it is unlikely that you will get a response on the same day. So just a piece to note that they're not going to give you anything in writing, which I find interesting. I do have some resource information listed on this slide, but I would highly recommend, if you haven't already, checking out the CFPB's website and reviewing the guidance documentation that they have available out there. And they also put some out on YouTube. If you think this is exciting, just wait till you try to click on some of those mortgage servicing YouTube videos. It's pretty painful. Last but not least, if you do have questions, I didn't mean to suck up all the time here today, but if you have questions or feel that your institution is actually in need of any regulatory compliance assistance, I can tell you that everyone on the team I work with would be happy to discuss your needs with you. If you already work with CliftonLarsonAllen, I can assure you that our team is more than prepared to answer your questions. If we don't work with you, this might be a great time to consider us. So since you're a captive audience, I had to put the old CliftonLarsonAllen plug in there. So I'm expecting that there are going to be some very specific questions that some of the financial institutions have been waiting to ask. And I can tell you that I'll do my best to answer some of them now. But if I can't get to them during the call here, we are going to keep a list of your questions as well as your contact information so that either myself or my team members can try to get back to you with those questions as soon as you can. So with that being said, let's open up the queue for some of your written questions. I believe the question function is actually located in the upper right-hand corner of your screen. Dan, if you've got anything, that would be great. I've got one question here I'm reading through. The first question reads, do you know if the new mortgage servicing rules regarding coupon books instead of periodic payments is only for applications received after January 10th, 2014, or for existing loans. I can only find the effective date of the rule and not whether existing loans are included. This is a great question, and I think I'm actually seeing another question that's coming across as well with how these new mortgage rules apply. If the rule itself actually doesn't note any variation between loans done before or after the 10th of January, my understanding is that since the rule is going to be effective for the period statement dates, or the periodic statement requirements, the coupon book is an exception that actually stems from those statement requirements. And my understanding is that any loan on the books or established after that date will be available under the existing new rules that start the 10th. So same thing. Are the sample notices provided by the CFPB for responding to? Oh, I'm sorry. I jumped ahead. This is a different question. Are there sample notices provided by the CFPB for responding to error and information requests? I believe that actually they do have a couple of pieces of terminology out there. Again, it's really going to be more detailed on the timing of what you actually do respond to. Most organizations are already going to have some pre-established templates and information that how you would probably be responding to those questions already. So I would say that when it comes to those specific notices, keep doing, in some respects, you can keep doing what you're doing, but I do believe that they have some model and form information that's connected right out there. I believe that would be in 1024, maybe section 35, I believe. Another question, too. If a member calls in with an error, do we have to tell them to send the request in writing? The rule actually requires that financial institutions follow certain procedures when it receives a notice of error from that borrower in writing. It does not actually require the notice of error to be specifically in writing, but if the financial institution does end up getting any error, notice over the phone, technically you don't have to reply in the same manner. I also would recommend not necessarily requiring them to write that. If it works out for the financial institution to be able to answer that request via any oral communication, you're better off doing that, because then technically it doesn't fall under the error resolution procedure requirements. This is a great one. What do you believe are the chances that these rules will be delayed from the January 10th, 2014 implementation date? I can tell you in the research that I did, it doesn't look good. There's all sorts of individuals that, really, if there's two camps. There's the camp that believes that these things are just going to continue to be pushed through, and then I think there's the hopeful camp that have come to the realization that this is going to create some major waves, and even though most of these financial institutions have been aware of this required change for quite some time, it takes a lot of manpower to get these things implemented and to get these policies changed. Just from a systematic standpoint, I'm not sure. I would be guessing, to be honest with you, if I said that it's going to be pushed back. I would say don't count on it. I would say let's get these things ready to go, because even if they do delay it, it's probably not going to be for a very long period of time, and you'll still need to be set up in order to be able to follow these rules. So that's probably the biggest thing. Oh, this one I think I covered, but I'll just make sure. Can a financial institution receive or respond to errors or information requests electronically? You can actually set up a process to receive notices of error or information requests through email, maybe in a website form, or other online intake methods. Maybe if you have a pop-up conversation window. But even if you have an online intake process, you still want to make sure that you offer your customers the option of submitting notices of error or those information requests by mail. Really, online can't be considered maybe just the exclusive mean of receiving those error requests or those information requests. We have a subservicing agreement that handles some of our portfolio. Some of the mortgages we take care of in-house, our total portfolio overall is less than $5,000. The servicer is a large company that has many loans and takes care of all the requirements of those loans. Are we exempt from the periodic statement and servicing requirements for mortgages that we keep in-house? I can say that, where a mortgage is sub-serviced, where it's serviced out, both the master servicer and the sub-servicer each individually have to meet the small servicer requirements in order to qualify for that exemption. But even if the sub-servicer does not qualify as a small servicer, the master servicer might still be eligible for the exemption for loans that it services in-house. So since you're not servicing loans for another entity, let's say you're the master servicer and not what's called the sub-servicer, you will not lose your exemption because one of your sub-servicers does not meet that small servicer exemption. The loans that non-exempt sub-servicer services will not qualify for is basically going to fall under that exemption. So assuming that you meet all the requirements of the sub-servicer exemption on your own, your loans held in-house should fall under that same exemption. And like I said before, if you continue to have questions, I would be happy to field them. We're going to be able to record those, and I believe tomorrow I'll be getting a list of those questions, and I'll do my best to try to respond to those in an immediate fashion. So again, if you actually already have an affiliation with someone from a regulatory compliance team, those guys are all definitely more than capable to answer your questions as well. So Dan, I think I'm going to hand it back to you.
Wonderful. Thank you, Adam, and thank you for participants. We covered a lot of great information, and thanks, Adam, for getting to those questions that you did. As Adam mentioned, if we weren't able to get to your question, we will be contacting you with the information. As a follow-up to today's session, we will be sending you an email with a link to the webinar recording and presentation slides within 10 business days. Thank you for your participation. You may now disconnect.